Hi everybody, and welcome again to the Victorian Disability Worker Commission's webinar on mandatory notifications. My name's Dan Stubbs. I'm the Victorian Disability Worker Commissioner, and I'm going to be leading the presentation. I commenced in this role in about November last year. Since that time, I and the rest of the team have been setting up the Victorian Disability Worker Commission. The Commission commenced its role on 1 July, so we're relatively new, and we're going to talk you through some of the key changes that result in, particularly around mandatory notifications. First, I'm pleased to just acknowledge that we're meeting on the land of the traditional owners, and I also acknowledge the elders of those traditional owners, past and present. And if there are any Aboriginal people listening or logged into this session today, I also acknowledge your presence. The changes that the Disability Services Safeguard Act introduces are significant for this sector. It provides new forms of oversight for workers, and it has implications on disability service providers too. It's also important, and probably most important in my view, for people with disabilities, their families and allies. If there was any doubt about how important it was, we only need to look at what's happening with the current Royal Commission and issues being raised on that front by people with disabilities and their advocates. And as recently as last Thursday's Melbourne Age, talking about challenges for another oversight body, the NDIS Quality and Safeguards Commission. So we think more than ever, there's greater safeguarding needed to protect, respect and empower people with disabilities in Victoria. And that work, we believe, will promote and ensure the health and the safety and the rights of people with disabilities in Victoria. I'm just going to introduce the people that are going to be speaking today. Obviously me, and I'll give an overview about what the Commission does and a little bit about how we work and why we exist. Maggie Whitmore is the Manager of Complaints, Investigations and Compliance. Maggie's going to speak in more detail about notifications, how you make notification, why you would do that, some practical understanding of our regulations and your compliance obligations under the Act. Then at the end, we're going to have a question and answer session where you'll be actually putting your questions, or we'll be answering some of the questions you've already put, and also other questions you've put through the Zoom Q&A function during the presentation. For that session on the panel, we'll also be joined by Susie Fry, who's the Commission's Principal Policy Advisor. So today we're going to cover the background to the Commission, why it exists, the key changes that it brings in, who's covered by the Act, the Disability Services Safeguards Act, the Code of Conduct, complaints, the mandatory notification scheme, which is the main reason for the session today, the powers of things like prohibition orders that we can make, and other regulators, what we call the co-regulatory environment. And finally, we'll provide you a range of ways that you can stay in contact with information and advice from the Commission. As you know, we're recording this session. The recording of the session will be posted online after it's finished. Please do share it with your colleagues. If there's anyone you think should see this session or wanted to come but couldn't listen to it live. There's also a extensive fact sheet giving guidance about notifications that we'll also post. So I also urge you to share that with your colleagues. We're going to be answering questions that you've already posted through Slido. And during the session today, we're hoping that you'll also be putting questions to us through the Q&A function in Zoom. So feel free to post those questions at any time. Obviously, there'll be time constraints, so there may be questions and issues that we don't get to. After the session, we'll provide further information in response to issues raised in the questions in general terms to the greatest degree possible. We'll also be making available a slide pack that provides all the information that you're going to hear us talk through today. So please don't feel like you need to be taking notes or anything. All the information is going to be written down. There's also going to be a transcript of the session provided with the key questions that you've asked. If you don't feel comfortable asking questions, then contact us directly, either through the website, there's our email address there, or our phone number, 1800 497 132. And obviously we take your attendance at this event as acceptance of the fact that we are recording, and information about your name when you post questions may be read out. So you may want to change your name, that's up to you. And so we'll be publishing this. Of course, it's live streaming right now. By way of background, there was a parliamentary inquiry back in 2016 that reported on abuse and neglect of people with disabilities in Victoria. The parliamentary inquiry recognised that the vast majority of workers were doing the right thing and doing incredible work for the sector at that time, but there was a significant minority that were not. Many of you will be aware of the Anne-Marie Smith case in Adelaide, and if you think that that was isolated to just an event in South Australia, you're sadly wrong, and you can see evidence of that in the reports and the evidence given in that parliamentary inquiry. So out of that inquiry came recommendations for this commission to be established for greater oversight, particularly of workers in Victoria. Victoria is the only jurisdiction in Australia that has this level of oversight that really demands and promotes safety and quality for people with disabilities in the services they receive. So on 1 July, as I said before, we established the new commission. The Disability Services Act is the act under which we operate. It covers all workers, all disability workers in Victoria. It doesn't matter how they're funded, you're covered by our legislation. It's more about the work you do rather than either the funding source or the level of government. It doesn't matter if the funding is privately provided or from government or charity even. It's about the fact that you do work for people with disabilities. There's a code of conduct, which is the same as the disability, the NDIS code of conduct. There's a notification scheme regarding conduct, which is a mandatory notification scheme, which we're obviously going to talk about more later. And there's obligations for workers and providers in regard to that, those notifications. There's a complaint system, and there's also going to be a registration of workers scheme. That's a voluntary registration scheme, which due to COVID has been deferred by 12 months. So we'll be telling you more about that next year. The voluntary disability worker registration scheme comes in on 1 July next year. And finally, there's also public registers that we're required to provide. That the public register is a register of banned or excluded disability workers based on complaints and notifications we receive and investigations we undertake. This scheme really reflects government and community expectations to create a stronger safeguards and oversight system in Victoria. It's about protecting people with disabilities and ensuring that providers and workers promote quality services for people with disabilities. There's 4 key elements of the scheme that we're going to talk about today. There's the code of conduct, there's the notification scheme, the complaints process, and the register. The code of conduct covers all disability workers in Victoria, and the coverage includes disability workers and those who supervise them. We don't necessarily oversight organisations, but the supervision of those workers are the people we also cover in that process. The code relates to the notification scheme too, so that's why I want to go through it in a little bit of detail, and Maggie will talk about or refer to the code of conduct as well. There's 7 elements to the code of conduct. The first is that disability workers must respect the right of people with disabilities to freedom of expression, self-determination, and decision-making. The second one is the need to respect the privacy of people with disabilities. And the third is to work for people with disabilities in a safe and competent manner with care and skill. The fourth one is the need for disability workers to operate with integrity and honesty and transparency. The fifth is about working in a way that promotes quality and safety of supports and services for people with disabilities. The sixth one is to avoid and stop violence and exploitation, neglect and abuse of people with disabilities. And the seventh and last one is to prevent any form of sexual misconduct in relation to people with disabilities. The next element is mandatory notifications. Workers and employers are obliged to make those notifications. You must report a worker to us if you have the reasonable belief that they have conducted themselves in a certain way. It's about conduct, not an incident, which is different to the way some other schemes require you to make notifications. So that we're seeking to have conduct reported to us, and ideally that, in many cases, will be in advance of a terrible incident. The sorts of things, and Meg will go into this in more detail, but the sorts of things you need to notify us about are in relation to working as a disability worker whilst intoxicated, sexual misconduct, operating in a way that will endanger people due to a worker's own impairment, and not working in accordance with recognised standards. We also have an independent complaints process. Anyone can complain. People with disabilities, members of the public, family members or friends of people with disabilities can all complain about the conduct of a worker, particularly in reference to the code of conduct that I went through before. It's an accessible it's an accessible complaint scheme. If a person with disability needs to complain, we will assist them to lodge that complaint if they contact us, and we'll be sharing the ways of contacting us at the end of the session. There's a public register, as I said before, where we have to publish the names and details of any disability worker who we've banned on the basis of what I would call serious misconduct. And that's after a proper process where there's been an investigation and there's been a fair hearing by everyone involved, and I've had to make a decision about that person being banned for either a period of time or permanently banned from the sector. As I said, all disability workers are covered. All people can complain in our system. The aim is really for people with disabilities to have certainty over the kinds of services they receive, regardless of who funds it or who provides it. And the intention is to improve quality and ensure safety for people with disabilities in Victoria. Again, I want to encourage you to keep in contact with what the Commission's doing. You can email us at info@vdwc.vic.gov.au, and we would love to subscribe you to our e-news for you to keep up to date. Right now, I'm going to now pass over to Maggie Whitmore. As I said, she's the Manager of Complaints, Investigations and Compliance with the Commission. And Maggie brings a lot of experience of serious investigation work. She's previously worked at the Disability Services Commission, and prior to that, she was at the Commission for Children and Young People of Victoria. Over to you, Maggie. Thanks.
Thanks, Dan. I would also like to acknowledge the traditional custodians of the land on which we meet, and I pay my respects to their elders past, present and emerging, and the Aboriginal elders of any other communities who may be here today. As Dan has talked about, I'm going to talk through the requirements of mandatory notification, and as you know, there'll be an opportunity to ask questions at the end, and I would encourage you to do so. As part of the regulation changes, all service providers and employers must report conduct that puts others at risk. If you're a disability worker or employ disability workers, then you are now required under the law to report certain conduct from disability workers that may put the people they support at risk. All disability workers and disability worker employers must make mandatory notifications to us, and if they form a reasonable belief that the disability worker has engaged in notifiable conduct, and that is now a requirement under the Disability Services and Safeguards Act of 2018. Workers and service providers have mandatory obligations to notify us as soon as practicable after they form a reasonable belief that the behaviour constitutes notifiable conduct. Section 58 of our Act defines notifiable conduct as when a disability worker has practiced as a disability worker while intoxicated by alcohol and drugs, engaged in sexual misconduct while practicing as a disability worker, placed or may place a person at risk because they have an impairment that detrimentally affects their ability to deliver services safely, or is placed or is placing the public at risk of harm because they are practicing in a manner that would constitute a significant departure from accepted professional standards. A notification requires that you form a reasonable belief about the conduct. To do so, you generally need to have direct knowledge of the incident or behaviour that has led to the concern. So it should be more than a suspicion. However, a reasonable belief doesn't require that you have certainty or evidence. You may have directly observed the incident or behaviour, or you may have a report from a reliable source or sources about the conduct they've experienced or observed. In that case, you could encourage the person with the most direct knowledge of the incident to consider whether they should be making the notification themselves. But if you're unsure or you want some further advice, just contact us for assistance, and we're happy to talk through it, assist you to fill out the web form on our portal, or to make a notification to us over the phone and we can record it. As Dan said, we want to be accessible, and we will work with you to do it in a way that best meets your needs. So the simplest way to make a notification is to contact us through the website, or you can call us on 1800 497 132, and we can provide you with any assistance you need. If you're making a notification and you want to keep your identity confidential, please let us know, and we'll take all reasonable steps to keep your details confidential. However, in some circumstances, we may be unable to do so, and if that is the case, we'll keep you informed of the reasons. Once the notification is received, we will assess it and determine the most suitable course of action. This may require us to contact you for further information or some clarification. We will work with the disability worker and let them know of the notification initially by phone and then in writing, except in the circumstances where it may prejudice an investigation. And we'll let them know the nature of that notification. Disability workers who are subject to a notification will be kept informed about the process all the way through and will be given opportunities to respond to the details of the notification. The Commissioner has several possible courses of action that he may decide on to take for a notification. These may include counselling the disability worker, referring it to an appropriate entity such as the National Disability Insurance Scheme Quality and Safeguards Commission, investigating the disability worker, taking other actions such as issuing an interim prohibition order or a prohibition order, or taking no further action. Once the suitable course of action has been determined, we must provide written notice to the disability worker advising them of the decision, except again in those circumstances where we believe that that would prejudice an investigation or place another person at risk or at risk of intimidation or harassment. Where we determine that a disability worker should be investigation, that investigation will follow the usual investigative procedures. What information we'll share with the notifier will depend on a lot of variables. So where possible, we'll keep you informed. However, it may not be possible in all circumstances. For instance, should a disability worker be the notifier from another organisation as opposed to an employer, we'd have limited powers to give information. In the circumstances we decide to investigate, however, you're likely to be contacted because we may need you to attend an interview to collect further information. However, should we resolve a matter through counselling or referring it to another entity, we may not be able to provide you with that information. The Act does allow us to share an investigation report to an employer or to someone who engages a disability worker if it's relevant to the engagement or employment of a disability worker. As mentioned also, Dan, or the Commissioner, has the ability to ban workers. So a prohibition order is a legally enforceable order issued by the Commissioner that bans an unregistered worker from providing all disability services or specified disability services, either for a limited time or permanently. So the Commissioner can make prohibition orders if he's satisfied that it is necessary to avoid serious risk to life, health, safety or welfare of a person or the health, safety, welfare of the public, and that an unregistered disability worker has breached the code of conduct or has been convicted or found guilty of a prescribed offence, has been issued an exclusion or a clearance suspended or revoked by the NDIS Worker Screening Unit, or is subject of an interim bar in relation to the NDIS Worker Screen Check, or is subject of a prohibition order or banning order by another regulator. The orders may be permanent or limited for a period of 12 weeks, the interim prohibition order, and they also may be revoked or amended or include conditions. All of the orders, including revocations, will be published on the Commission's website, and they'll include the name of the worker, the type of the order, and the dates of effect, and any conditions that are associated with those orders. As Dan mentioned, we work in a co-regulatory environment, and that just simply means that there's a number of regulators in this space, both national and state-based regulators. And our legislation provides for us to work with those other bodies. And it's anticipated that we will share information, and our Act has been written in a way that allows us to do that quite easily. So we're currently working really closely with those other regulators to ensure that there is a no wrong door approach for notifiers and complainants. And we're currently developing our protocols and memorandums of understandings with a number of different regulators, and this allows us to support the complainants because we want to minimise the amount of times people have to tell their story and retell their story and tell it to different people. We've got protocols for who will communicate with the complainant, so again, they feel supported. They're not confused about who is doing what, and we can all understand what the issue is and what we need to resolve. And it also allows us to take action working cooperatively with the other entities, or to wait while another entity is undertaking investigations, such as Victoria Police, and then follow up with our process. Because we need to ensure that we're working together so that we have the best outcome for people with disability. So for example, if a disability worker was a registered nurse, we'd be working with AHPRA and ensuring that they follow their processes so people can't move from one sector to another if we consider that they pose a risk. So some examples of the entities we're sharing information with is the NDIS Quality Safeguards Commission, who are actually required to also, under our Act, refer any matters where the complaint or notification relates to a worker who's engaged by a registered NDIS provider. We're working with the Health Complaints Commission in Victoria, the Disability Services Commission in Victoria, AHPRA, which is obviously a federal body, the Secretary of the Department of Justice and Community Safety, the Secretary of the Department of Health and Human Services, the Victorian Institute of Teaching, and the Mental Health Complaints Commission. But our Act also allows us to share information with interstate health entities who may deal with a person's behaviour or their professional misconduct, unsatisfactory professional performance or unprofessional conduct. And those entities are actually prescribed in our regulations. And again, they allow us to share information quite easily. And we have some reciprocal banning processes in place. So if a body such as the Health Complaints Commission or AHPRA have banned a worker, we're able to use that banning order then to underpin and develop our own banning order. And now I'll hand back to the Commissioner for questions.
Thanks, Maggie. That's great. Now over to you for your questions. Let's look at some of those questions. Thanks, everyone.